May I please, your lordship?
Yes, please.
My lord, I am playing for listing one anticipatory bail application filed on 23rd.
I think there is a.
It is also number lordship.
Huh?
Above 7 years only this bench is sitting to the lordship.
No, if there is other bench taking the matter, then you
No,
please.
no, only this honorable bench is available.
Have you verified?
Yes, lordship.
Huh?
Yes, lordship.
More than 7 years,
Right, you give it, but he will verify. Subject to verification, it will be allowed.
Lordship.
When do you want it?
Tomorrow.
Not tomorrow, Wednesday.
Lordship. Obliged, lordship. My pleasure, lordship. My lord, I have a prayer in item number 9, my lord. Lord, I don't want to press this petition, my lord, since the matter has been amicably settled between the parties, my lord.
Mr.
Zed Hamad.
Mr. Jed Hamid Hamad, learned counsel for the petitioner submits that the petitioner has instructed not to press the instant anticipatory bail application and accordingly seeks withdrawal of the same. PP, who's there? PP, P. Sharma, right? KK Parasha, sorry. Give it the KK Parasha's name, huh? In view of the aforesaid endorsement, the anticipatory bail application stands dismissed on being withdrawn.
I'm deeply
But this is for withdrawal tomorrow, man. Deeply.
That is your lordship. But on behalf of Mr. N.J. Dottomalat, I'd like to mention item number 24.
Item number
24, madam. He's not out of station for the day, madam. So, my lord, adjournment
24.
24, madam.
As prayed for, relist after 1 week on a date to be fixed by the registry.
Deeply, lordship.
Thank you.
May I please, your lordship? I would like to mention item number 22. File additional affidavit. lordship.
20?
22 and 23. lordship.
Yes, what do you want?
We will file an additional affidavit. lordship. That on 1st of May, lordship.
You want time for filing additional affidavit.
Yes, lord.
As prayed for by MS,
Miss Nuri Asma.
Your
Begum
name.
And A. Begum, lordship.
N.A. Begum, learned counsel for the petitioner relist after 1 week.
Lordship, kindly let the matter come on 1st of May, lordship.
After 1 week on a date to be fixed by the registry to enable the petitioner to file the additional affidavit as prayed for.
Obliged, lordship.
May I please, your lordship? Lordship, I beg to mention item number 35, lordship.
30?
Lordship, my senior has some personal difficulty today. Matter may be adjourned for the day.
CD is there. CD is available.
Week any date, lordship.
Yes, Mr. Parasar.
Regarding who is protected, lordship? Is-
Already? On interim. Okay, one is not there.
Oh,
All right, as prayed for, relist after 1 week on a date to be fixed by the registry.
CD may be retained, lordship.
Retain the CD.
Obliged, lordship. Lordship, sorry, lordship. Lordship, interim was there, lordship.
In respect of
Number 2.
interim, if any, interim in respect of petitioner number 2, if any, shall continue till the next date of listing.
Obliged.
One regular first appeal, there is a condemnation, lordship. We already issued not that. Either lordship in orders.
The condonation application.
We've already notice issued and we take.
All right.
Obliged, lordship.
May I please, your lordship? Lordship, in respect to item 21, your lordship.
Yes.
Kindly pass over the matter for the day.
21. 21 is a bail. CD is there.
A scan copy, my lord.
All right. As prayed for, relist
Next year.
after a week on a date to be fixed by the registry.
May I please, your lordship, I beg to mention an anticipatory bail. The person concerned is a government officer and his election duty has come on 7th of May, your lordship.
Is this the appropriate bench?
Special acts with fresh application, your lordship, fresh anticipatory bail application.
You
May be
give it
listed
subject to verification. Subject to verification
tomorrow.
only.
Indeed, your lordship. May be listed tomorrow, lordship, for motion only.
Wednesday.
So obliged, lordship.
Would I verify correctly? Yes, please call the list. CD, Mr. Manan. Scan copy or CD? It's an NDPS.
Because already
All right.
Charge sheet has been filed and
Call for scanned copy of the case records from the court of
court of the Special Judge Kamrup Amingaon.
Special Judge Kamrup
Amingaon,
Amingaon.
NDPS case number 20
From the court of Special Judge Kamrup Amingaon, huh? In connection with the NDPS case number 20 of 2023 corresponding to NCB crime number 23/2022. Okay. List on. Yes, when
First week of May,
you are for whom?
I am for NCB, I am appearing on behalf of SCKR.
Okay.
NCB. It's for
NCB.
NCB.
Dated the date of list on such and such date.
Much obliged.
Can it be a little bit earlier? 9 to come on.
6th,
Much obliged.
kidnapping women.
Lordship, there's a discrepancies. Lordship would see.
All right, let the CDB call for.
Lordship kindly see.
Short date.
Short date, Lordship.
Timothy, my lord,
Timothy.
Next.
second, my lord.
Next,
Deeply obliged.
POXO.
Yes, sir.
Yes, I have it. Court of District and Session Judge Sri Bhumi, in connection with special NDPS case number 62 of 2024, arising out of Karimganj Police Station case number 357 of 2024. List on such and such. 376.
Lordship, but there is, it is a false case, Lordship, and
TD, list on,
Lordship, on submission, Lordship.
list on.
Gwalpara, my lord, 13th.
Before that,
Earlier, Lordship.
Nine.
38 days.
9.
9, my lord.
Yes, next.
Published.
May I please, your lordship? Lordship,
Which police station?
may I please, lordship?
Which police station?
Lordship,
Dispur,
Dispur.
Huh?
Dispur,
Dispur.
lordship.
Yes, next week.
Lordship, may I please?
Next
lordship?
week.
Lordship,
CD
Case
and
number 21, lordship.
sorry,
Please,
not
Day after
it's
tomorrow,
a
lordship, his elder brother's marriage is there, lordship.
Friday.
Lordship, day after tomorrow, his elder brother's.
This
Day after tomorrow.
Day after
All
tomorrow.
right, Wednesday.
Lordship.
We'll
lordship,
try on Wednesday.
lordship, day after tomorrow. On that day, marriage will be solemnized, lordship. His elder brother's on his own
Next.
residence.
Item number 8.
Can you have it available tomorrow?
Lordship.
My lord,
May I
It's
read
from
the-
Dispur.
this one?
All
Lordship,
right, tomorrow. Correct.
may I read the FIR, lordship? There is
Yes,
nothing there.
next. No cognizance has been taken in this matter.
my lord, yes.
FIR is not registered.
FIR not registered, but one report was called from this PS report also not received.
So await report.
My lord,
Await report as called for by order dated 14/2/2025. Passed earlier by this court. Huh? List on such and such date. And on top you may say
Seventh.
none appears for the petitioner on call. Heard Mr. KK Parashar, learned APP for the state respondent.
6th of
All right.
Item number 10. So item number 9.
No, 9 is disposed of.
Item 10.
Yes, 10. Which page is the FIR?
Two FIRs are there, my lord.
Hmm.
My lord, I am taking bail in the FIR page
Hey.
23.
Just 1 second. Look. ইনো বস্তুবোৰ ক'ত থলে মই প্ৰতিষ্ঠাতা এইখিনি নহয় নহয়
subsequently it added no 103.
এবাৰ বিডিকা কৰি দিওঁ
My lord, SB's version, my lord, page
Page,
23.
page?
Page 23.
page 11
Page 23, my lord.
page 23
Translated copy at page 18.
yes please read
সম্মানপূর্বক বিনীত নিবেদন এই যে জুয়া ইংরাজি 13/3/25 তারিখে রাতি অনুমান 11টামান বজাত মোৰ সৰু ভাইটি শ্ৰী লাৰু গোপাল ৰয়ে ভুল বশত মদ খাই উপৰোক্ত 1 নং পদকীয়াৰ তামোল বাগানত সোমাই পৰে পদকীয়াগণে সুর ধন্দে করি বেয়াকৈ মারপিট করি শরীরের বিভিন্ন অংশত আঘাত করে
Let him be, I don't think custodial.
No, no, but he subsequently that man expired, my lord, in hospital.
after 7 days
So 103 a day, my lord.
All right,
Postmortem report,
let him appear.
but with how much, my lord, with what weapon it was, my lord.
That's all
My
right.
lord, if you will lordship, my lord, kindly see the page 25. Police themselves, my lord, said that it was public, my lord, who assaulted. Page 25, my lord.
Ultimately, the person died, my lord, CD and the postmortem report at this stage, my lord.
All right, this is item number 10.
10, my lord.
Heard Mr. S. Chauhan, learned counsel for the petitioner, also heard Mr. K.K. Parashar, learned APP for the state respondent. This is an application under section 482 of BNSS 2023 seeking grant of pre-arrest bail to the petitioner i.e. Shri Khyam Niwar, who is apprehending arrest in connection with Rauta PS case number 30 of 2025. Stop. Registered under section 3032 of BNSS. There is the cross FIR is filed by you.
My lord, it's prayer.
We,
Prayer to them.
that is that page.
It page, my lord, translated copy, my lord, it is page 11.
Page 11. Okay. Call for the case diary fixing the matter on. Yes, please give a date on such
My
and
lord,
such
the
date.
9th.
It appears that
My lord.
My lord, one thing is, my lord, that 303 is going to be, it is case, he is seeking, my lord, case number
30.
30. That is registered under section 126 to 1172, 3 within bracket 5 and subsequently added section 103.
section,
Page,
section,
page 19, my lord.
page 19.
Page 19.
Okay. Registered under section 1262,
Yeah, 1,
1172 and 35
35 and
subsequently added
103,
section
103 of
103
BNS.
of BNSS. This you will get in page 1 only, huh? Towards the end. Okay. Then you say
Out of 3 named accused, my lord, 2 already arrested.
Mr. So-and-so learned counsel for the petitioner submits that the
Case number, my lord, I may be wrong. my lord.
Lalu Gopal Ray, who is he?
He was the thief, my lord.
Huh?
He entered the Betelnut garden at night of 11 p.m., my lord. He was the
Submits that one Lalu Gopal Ray, who was caught red-handed on 13/2/2025 at 11:15 p.m. while he was stealing betel nuts. Stop. Not stop, comma. The brother of the petitioner and many others gathered after hearing hue and cry. However, subsequently,
Again on 13/3.
it appears that an FIR was filed alleging the petitioner as one of the assailant. Correct? And stop. He further submits that where is the cross FIR? That prior to the FIR dated 15/3/2025, as regards the incident which occurred on 13/3/2025. A cross of FIR.
My lord, 15-3 at page 23, my
No,
lord.
who has filed the cross FIR?
Cross FIR filed by my lord, the sister of the thief.
And 13/3 is filed by whom?
30 filed by my lord, Champa Deka.
You are named in which FIR? 13/3 or 15/8?
In 30, my lord.
In 13/3, right?
30.
13/3, right?
30.
30. Where is that 30 FIR?
My lord, senior is
Before my-
confused, my lord, that thing, my lord.
E-
Earlier FIR was registered, my lord, registered as.
The
my lord,
facts have been not correct,
Yes, yes, my lord.
appropriately placed.
First,
My lord, first FIR.
One
FIR
second, please.
first
yes.
FIR was page 12, my lord.
Hmm.
12 First FIR is there, 29/25.
Yes, number, yes.
29/25. And he is seeking bail in the FIR
Page 18.
page 18. That is 30/25.
Yes.
When the, my lord,
And from where it is shown that he subsequently died, the person?
my lord, they have,
Police report is there.
police report is there, they have mentioned, my lord.
How much time will you take to have the CD?
From Udalguri,
Rota, I think Rota.
yes, Rota. My lord, because 7 is
Next
the
week?
date of election, my lord.
Next week, if you are getting it next week, I'm
Next week, my lord, next
not
week.
granting anything
Ne-
right now. Let
ne-
us have the CD.
Next week, my lord, 9th,
Since the person have died, I was thinking of considering, but
9th, my lord.
call for CD list on such and such date.
Nine, my lord,
Yes, next.
No, 7 to election. আছে তো।
item number 11.
Next is the application of BNS lordship.
FIR,
There is a quarrel between the petitioner and the informant and the
FIR.
FIR page 8. There is a two FIR laws against each other lordship. Cross FIR, there is a court and page 18 is a FIR laws against us lordship.
You are, which one?
I am page 28.
Page
Which is-
18, page 8,
28 lordship.
Huh? not
Page
the
to-
page 8.
Page 28 laws against us lordship and page 8 is I have laws.
That was by you.
Page 28 is I have laws lordship and
Page
20
28.
page 28 lordship. This is one laws against us. Lordship.
You are accused number 3 accused. So you are for all.
All.
Let's read.
Page, may I please.
Yes.
I have the honor to state that my house and that of the accused person are situated in the same balance. And an amount of rupees 1,70,000 remain due to us from accused number 1. Around 9 AM today, that is on 11/2/2025, when my younger brother Dilwar Hussain went to the shop of the accused number 1, situated at Puthimari market, and asked for the money. The accused person assaulted him severely, severely with an intention of killing him in a planned way. When my father Hasmat Ali, uncle Latif Ali, and his son, my cousin brother, my Babul Ali, who were in the market, came forward, the accused person assaulted them too, and thus caused grievous injuries to them. When they raised a scream for being assaulted by the accused person, the people of market.
When, Mr. Parashar?
9th, my lord.
9th. Call for CD list on 9. Yes, next.
They
Let us
are
see-
under
let us
treatment.
see
Lordship.
what are the nature of injuries? Yes.
May I please, your lordship. The FIR is a page 14, lordship.
Any, is there a connected AB pending?
No, lordship.
ये तो यहाँ पर क्यों लैग also, sir?
Whatever, lordship, the
1 second, please. ये तो यहाँ पर अने क्यों लैग ऐसा? हाँ ये तो सब मारेगा. Yes, FIR page
page 14, lordship.
page 14.
14, 1/4, lordship. Translated copy, lordship. FIR lodged by informant who is lordship, sister-in-law of petitioner number 1. May read, lordship.
Page 20.
14, lordship. 14, 1/4.
Yes, please read.
with due respect, it is submitted that the below mentioned accused number 1 had tried to establish a brick lane illegally near our house, and in this regard, the local people of the said locality lodged a written complaint against said brick lane. And in that regard, the accused number 1 being subject to unjust greed and suspected me and my husband, and he had been trying to harass me and my husband in different ways. As per the advice of the accused number 2, 3, 4, and 5. I am for accused number 2, 3, and 4, Lordship.
You are for
3, 4.
2, 3, 4.
Moreover, 25 days ago, the accused persons poisoned our fishery. As a result, many fishes died and caused huge financial losses. Consequently, quarrel had took place between us under such circumstances on 20/2/2025 at around 2 p.m. while my husband was fishing in our pond. The accused 2, 3, 4, and 5 become aggressive and beaten my husband severely with sharp weapon like lathi, phala, dao.
Head got fractured. Allegations are serious.
Yes,
When?
head 13th from Thugri.
CD 13.
There are also civil disputes pending also.
Let us see. All right.
Let us see the injury on 13.
Oblige, Lordship.
Yes, please, Mr. Bhattakur.
Application under section 482, your lordship.
FIR
Page 16, your lordship. I am not named in the FIR, your lordship.
not named.
Not named.
Yes.
Your lordship, it is allegation is that the accused number 1 and the accused number 2 by connivance, your lordship.
They were?
They by conniving among themselves, your lordship, sold out the land belonging to the informant, your lordship.
Why are you
I am
apprehending arrest?
apprehending, your lordship, because your lordship, I have been issued with a notice under section 35(3), your lordship. And your lordship 35(3), as your lordship knows, is issued to an accused, your lordship. In fact, I am a 75-year-old man, your lordship.
Yes, Mr. Parashar.
Considering the age my lord only, my lord.
All right. Heard Mr. S. Bhattakur, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned APP for the state respondent. This is an application under section 482 BNSS 2023 seeking pre-arrest bail to the petitioner, I. Shri Lakshmi Ram Saikya, Alice Lakhi Ram Saikya, who is apprehending arrest in connection with Bayahata Chareli Police Station case number 83 of 2025, registered under section 3184, 3165, 3363, 338, 33, 7, 3402, 35 of the BNSS 2023. Stop. Call for the case diary fixing the matter on
My lord, the 19.
19th, so and so. Considering the facts and circumstances of the case, especially that the accused is not named in the FIR and is aged about 75 years, it is provided that in the event of arrest, the petitioner named above shall be released on interim pre-arrest bail in connection with the above noted case on furnishing bail bond of rupees 15,000 with one surety of the amount to the satisfaction of the arresting authority, subject of course to the following conditions, the 3 conditions, and list accordingly.
If your
14.
Please, your lordship. My lord, in this case, lordship, FIR is page 5, type copy is page 10, and original copy vernacular page 14, lordship.
Page 14.
14.
Yes, please read.
14. May I read, lordship?
Read.
এজারকারী বিনীত নিবেদনে এই যে জুয়াকালী 6/6/7
Where is the translated copy?
page 10.
Read.
May I read, lordship? The informant states that yesterday on 6/4/25 at around 11 a.m., my daughter, Miss Nargis Sultana, was taken away. The age of the girl
Is not attracted.
Fact, my lord,
This is a bail application. This is not a revision.
and this is also, my lord,
When is the next date? This is also what?
fact, it is, my lord, The extension has been, my lord, the investigation has been
Counsel-
extended.
Mr. Counsel, what is this application file under?
That is, my lord, though it's a regular bail
What is
application.
this?
Yes, my lord.
Mr. Counsel, please be mindful and answer the queries that
Yes.
the court is asking.
Yes. In fact, it's a.
Is this a bail application or not?
Yes.
Then
Yes,
then
in
how
fact,
can
my
you
lord,
impugn something else in a bail application?
in bail application also, your lordship may, my lord, consider this aspect of the matter, my lord.
Sorry, anyway, but you said the next date is on 10/4 for the production?
Yes, my lord.
So I'm
Ten-
fixing it on 12. By then, let us see what happens.
Yes, yes.
12 or,
In the meantime, my lord, updated scan copy may be called.
that's what, it is submitted at the, Mr. KK Parashar, and APP submits that
Yes, sir.
10/4/2025 is fixed for submission, for production of the accused and the,
And my lord, copy.
Uh,
Copy.
huh?
For production of copy, my lord.
for production of copy.
My lord.
For production of copy. List, no, call for the updated scan copy of the case records. List on such and such date, give a date. And on
In May, 1/3.
one second. One second.
Your lordship, the charges has already been framed, but from the perusal of the records, lordship, I have seen that the next date was fixed for evidence on 3/3/25.
3/3.
25, the evidence was fixed, lordship.
Hmm.
The records are not updated, lordship, before your lordship.
So far, the petitioner in Nakulboro is concerned, my lord. As per FIR, my lord, the offense committed in my room, and I have seen the offense.
This is under POCSO.
Team lordship,
Anyway,
lordship.
let us see the FIR. Yeah, Mr. Parashar, case diary available?
But,
That bench is not available.
yes, scan copy is there. Earlier, this case was once rejected by Justice.
Honorable
Honor-
Justice Khan, but
Khan.
that bench is not available.
Oh,
And other queries were subsequently granted bail by the.
No. But bench is otherwise available.
Not available. It
No, it is in
not
station.
Not in station, and if it is not in the.
Justice Fukan, I think, is there in station. CB1 लो है ऐसे की ऑप्शन
session 9.
is available. So you have a, I'm just keeping it for some time. Please check about hoodie lock bench. Mr. Ahmed, just wait for a second.
Lock.
Hoodie lock. Yes, call the next.
Number 25.
বুঝিলে না কি হুডি বা কন্টেও আছে স্টেশনত আছে
This case, my LCR is called for, my lord. Can copy of the case.
Yes, has it come?
25.
Scan copy has received.
Have you gone through or not
Maybe after some time.
after some time? Yes, Mr. Sharma.
My voluminous my lord scan copy, my lord. Kindly at fix at 2, my lord.
Two?
I'll go through, my lord.
All right.
Publish.
এটা দুটাত হা
26.
Malat, this is Panbazar PS case number, Malat. CD will come, Malat, maybe taken at 2, Malat.
all right itu at 2
27.
27, there is a official, Malat, perhaps scan copy is not received.
not received.
May I submit, Lordship? Lordship, as the grounds of arrest not been informed and
Await
According
for scan copy of the case records as called earlier by this court. List on such and such date.
may be fixed on 5th, Lordship, may, as because election is there, concert election.
Next.
Okay. Item number 28. Wait, please, your Lordship.
Here also, Malat, office note is there, Malat, scan copy perhaps not received, Malat. At 29 to 7.
Await scan copy. of the case records as called for earlier by this court. List on such and such date.
Please.
Item number 29.
29, Lordship, the office note dated 24/4/25.
None appears for the petitioner on call. Yes.
The office note dated 24/4/25, Lordship, it indicates, Lordship, that the service report is still awaited, Lordship.
You are
B. Sharma.
B. Sharma, right? Mr. B. Sharma at APP for the state draws the attention of the court to the office note dated
24/4.
24/4/25, which reflects that service in respect of the informant,
Yes, respondent.
respondent number 2
Yes.
is still awaited. List after 2 weeks
Lordship.
on a date to be fixed by the registry.
Kindly pass over for timing.
Okay.
Bless.
There is an office note.
Yes, Mr. Biswas,
My lord, this
scan
man was,
copy,
yes, it's there.
it's there.
My lord, this man was arrested on 16/3/2021.
16/3/21.
Wow.
What is the status of the trial?
Out of 10, only 5 witnesses has been examined.
Out of 10, 5.
5. 4 years, 1 month, 13 days.
4 years, 1 month,
13 days.
13 days.
And if we calculate it in terms of days, then it is 1,505 days.
Only thing, this is NDPS. The rigor of 37 is there. So you have to first satisfy, because that alone perhaps would not be a ground.
Rigors of 37, Supreme Court says if somebody has been in incarceration.
Which case?
Ravi Prakash.
Where is it?
The Ravi Prakash.
In a case of
NDPS commercial.
let us see.
Once somebody has spent, once somebody has undergone incarceration for 3.5 years, Section 37 rigors would not
Let
apply.
us see.
Ravi Prakash? Ravi Prakash?
Yes, paragraph.
Paragraph. My lord, 4.
Paragraph 4. Yes.
As regard to the twin condition contained in Section 37 of the NDPS Act, Learned Counsel for the respondent state has duly been heard. Because one of the condition is.
Yes, please read.
Thus, the first condition stands complied with. So far as the second
That
ground.
means first complied means reasonable ground.
No, first one is giving opportunity to the people.
Oh, acha.
Thus, because in this case, notice
Alright,
was issued.
alright.
So the second ground to believe that the petitioner is not guilty, the same may not be formed at this stage when he has already spent more than 3.5 years in custody.
In your case, 4 years?
4 years.
1 month?
1 month, 13 days.
13 days. Yes.
And not guilty, the same may not be formed at this stage when he has spent more than 3.5 years. The prolonged incarceration generally mitigates against.
All right.
Lordship, Mr. KL will submit for a
What?
timing, Lordship.
What timing?
For the timing, Lordship.
Every case.
He is on
This
license court
person-
number 9, Lordship.
Huh?
He will appear.
And this person has to be released. He's been in custody for last more than 4 years
My lord,
and more.
In fact-
And it appears that the trial is
That is apparent.
going through in a very
nail base.
that was the word which I was looking for. Speed. Huh?
Lordship,
Out of 10, only 5 has. And when did the trial started, Mr. Biswal?
My lord, charges was framed in 31/7/2023.
31,
7/23.
7, 23 charges. And when did the evidences started?
That I'll have to, because immediately after.
Anyway, just have a look at it.
What happens in NCB cases, what they do is that, suppose there are 3 accused persons, they will arrest one. Somehow to defeat that mandatory period of 180 days, they will hurriedly file a charge sheet. And then they will shift the burden on the court. They will ask the court to issue.
Just wait for some time. Let Mr. Kyle, because since he's making a request
Lordship, in this case, Lordship, the
Office note is. What does the office note say? Mr. Kaushik, you're appearing here.
My lord, yes.
What is the office note? It says it's fixed with an office note.
Service, my lord.
Oh, scan copy is still awaited. It appears that the scan copy of the case record as called earlier from the trial court is still awaited. List, yes, give a date.
It is from Kamrup Metro, Guwahati, Lordship, and.
Yes, list.
Any date, my lord.
566, Lordship can.
All right.
Published. Published.
Hello, dear, 21B, and petitioner have already undergone a statutory period of like
So,
yesterday.
you have the case diary?
Yes, my lord, we have the case diary without official report and our calculation, my lord,
Yesterday-
today is 59 days.
59.
Yes,
Tomorrow is mandatory period.
I think then
diary is here. man.
That is here, my lord.
Diary is here, there is no possibility.
there is no what? There is no possible.
There is no possibility for tomorrow,
21B.
21B.
So 37 will not come. Huh? Mr. Parashar? Sorry?
80 grams of heroin,
Oh, the quantity is small. 80.
80 grams,
80.
80.
NDPS, huh? Heard Mr.
Yeah.
A.I. Uddin, learned counsel for the petitioner. Also heard Mr. R.R. Kaushik, learned APP for the state respondent. This application is filed under section 483 of the BNSS 2023, praying for granting bail to the petitioner, i.e. MD Rajibul Islam, who has been arrested on, not arrested, who has been in custody since 28/2/2025 in connection with Laluk Police Station case number 43 of 2025, registered under section 21B/29 of the Narcotic Drugs and Psychotropic Substance Act 1985. Stop. The facts of the case is that on 24/11/2024, an FIR was lodged alleging inter alia that on 27/2/2025, the police, based on a secret information, after making a GD entry, conducted a Naka checking at Harmuti area, and during such checking, the police intercepted a white color Dustin Redigo vehicle bearing registration number AS07T9803, from where 7 numbers of soap boxes were recovered, which contained light orange color suspected heroin totaling of 80 grams. Stop. Accordingly, a case was registered under section 21B/29 of the NDPS so and so against the petitioner and anybody else
Petitioner.
against the petitioner. Thereafter, the petitioner was arrested on 27, and then accordingly, the petitioner was arrested on 27/2/2025, and on the next day, 28/2/2025, he was forwarded to
Chief Judicial
the
Magistrate.
court of learned special judge Lokhimpur, wherefrom he was remanded to the judicial custody. And since then, he has been languishing in jail hazard. Stop. Mr. So-and-so submits that the petitioner is innocent and in no way involved with the alleged commission of crime, and that he was arrested on mere suspicion and during police custody, he was subjected to severe torture by the police officer of higher rank, which made him make self-implicating statements. Stop. He further submits that the mandatory period of 60 days is going to end tomorrow, and the quantity recovered is very less. He accordingly prays for releasing the petitioner on bail. Stop. Per contra, Mr. R.R. Kaushik so-and-so, yes, fairly submits or oppose? Fairly submits that the quantity of the narcotic substance being less and the fact that the mandatory period of 60 days is coming to an end tomorrow and the case diary being available in court, there is no possibility of the investigation.
No, I'm not submitting that. I'm submitting them, my lord. The FSL not received. The case diary is here, my lord.
No, but it will not get over.
It will not get over.
That is what.
That is right. But FSL not received.
The investigation, the charge sheet cannot be filed. That's what I'm submitting. Ki likhila? That the case records being available in the court, the charge sheet is unlikely to be filed by tomorrow, i.e. within the mandatory period. Stop. I've only said that much. Okay. Heard, perused records, the case diary. It appears that the charge sheet is unlikely to be filed by tomorrow within the mandatory period in as much as the case diary is in court. That it further appears that the quantity of the contraband article seized is 80
intermediate quantity.
Is intermediate quantity. Stop. Considering the totality of the facts and circumstances of the case, and especially that the quantity is so and so, comma, it is provided that the accused petitioner named above shall be released on bail of rupees 50,000 with 2 government sureties of like amount as submitted by the learned counsel for the accused petitioner to the satisfaction of the learned special judge Lokhimpur, subject to the following conditions, 1, 2, 3 DD.
One government surety. One government, one local surety.
Okay. One government, one.
Oblige.
Disposes of the bail application. And a breach of any of the above conditions shall render the cancellation of the bail in accordance with law.
Oblige.
Can be item 48.
I'm sorry, Your Lordship, I was late.
48.
Your Lordship, I'm sorry.
Yes.
Lordship, scan copy was called for, Lordship. Though
It has not come.
No.
Await for the scanned copy of the case records as called earlier by this court. List on such and such date.
Much obliged, Your Lord.
All right, Mr. Munir.
No.
Yes.
Bail hearing, item number 30.
30 CD not received, my lord.
Huh?
Petitioner is on interim, my lord.
30.
30.
No, like, await for CD.
CD.
Await for CD interim interim order as passed earlier shall continue till the next date of listing. List on such and such date.
13.
Item number 31.
CD.
Please, your lord. Lordship, we have not up to the diary was called for, lordship.
Huh? Not there.
CD is here, but my lord, this is not up to date, my lord.
Not up to date.
Not up to
On interim.
on interim.
All right. Mr. R.R. Kaushik, learned APP for the state submits that though the case diary is available, however, the up-to-date case diary is not received till date. Let the up-to-date case diary be produced on the next date of listing. A list on such and such date, interim passed earlier shall continue till the next date of listing.
26 May. Interim is.
Your lordship, this is bail application 482, my lord, and FIR is page 11, my lord.
CD,
My lord, here. the CD
updated case diary was also called.
Yes, my lord.
You have it?
Not up to date, my lord.
Not there.
Not there. Last update on 29.
On interim.
My lord, I am politically activate, my lord, because of this, my lord, my name is not in the FIR.
Where is it going to come from, Mr. Kaushik?
My lord, Pukrajhar, my lord.
Why is it taking so much time?
My lord.
It was
On last
on
it was
7th April.
7/4, my lord.
Prior to that, in February only it was called. No, but the case diary was received and
Case
then
diary received, my
updated.
lord. Yes.
So
Last
the-
chance, my lord.
Hmm?
Either
Next week?
next week, my lord, because of due to this election, it may be difficult. So
But as the case diary that is available, anything, any materials?
my learned friend Bhaskar Sharma has gone through this CD.
What is the FIR? Let's see the FIR.
My lord, page 11, my lord.
Page 11. Yes,
May I read, my lord?
yes.
I am writing to officially bring to your attention that an illegal activity taking place near the entrance of our plant through gate number 5. It has come to our notice that some unauthorized persons have been demanding money from goods truck that bring material to our plant. This unlawful activity is causing significant inconvenience to our operations and threatening
All right, yes. When? It appears that the updated case diary as called for is still awaited. List on such and such date. Please give us a short date.
I know last chance, my lord.
My lord, on 14th.
All right.
Item number 23.
Yes. Case diary
33 started submitted, my lord.
submitted.
Submitted. Wednesday.
What is to be done? Then appears for the petitioner on call. List again on
Next week. Maybe.
such and such date. Interim is there.
As per my note, no interim.
Okay.
Item 34.
Yes.
CD is called for, my lord.
Not received, my lord.
Await CD, send reminder. No, not await CD, list on such and such date.
Again, you can.
Interim, if any, shall continue
On 26.
till the next date of listing.
6.
That's it. 36 also, there is no CD, my lord.
No CD.
On interim.
Await CD, list on such and such date. Interim, if any, interim order passed earlier shall continue till the next date of
23rd.
listing.
37.
Wait, please, your lordship. Lordship, this is an anticipatory bail
CD?
application, lordship.
Not received, my lord.
Why no CD is there?
Lord, from Dhuburi.
Huh? Anyway, for matters that which are going to be fixed for the next few days, please send reminders for the at least for the hearing matters, because otherwise there will be nothing for this court to do. Yes.
Lordship, one more pair, Lordship, regarding petition number 2, Lordship, he has already been arrested, Lordship, his name kindly be struck off, Lordship.
Mr. Yeah, this is item number
37.
37. Mr. B. Chaudhary, right? Mr. B. Chaudhary, learned counsel for the petitioner, submits that pending adjudication of the instant anticipatory bail application, the petitioner number 2 has already been arrested. Accordingly, he seeks striking off. Accordingly, he submits that the instant anticipatory bail application is not pressed on behalf of petitioner number 2. Anything else to be said?
Regarding
In view of the aforesaid endorsement, the name of the petitioner number 2 be struck off from the arraignment of parties. Then, in view of the aforesaid endorsement, I think his name has to be struck off because he'll probably have to come for a bail application. Be struck off from the cause list, from the cause title. Let amended cause title be submitted in this regard before the registry for doing the needful. As regards the case diary,
that part is not required, Lordship, because Lordship, already been arrested, Lordship, I'm not pressing for him, Lordship.
but tomorrow you have to file a bail application.
He has already, until unless moved there, Lordship, he is a juvenile, Lordship, the juvenile court has to consider it.
ঠিক আছে, সেইটো নালাগে বাৰু। ইমানখিনি থৈ দিয়া, হা? And it appears that case diary is still awaited, list on such and such date.
Lordship, may I pray, Lordship, regarding petition number 4, Lordship, she is a lady, Lordship, 55 years, Lordship, no allegation against her, Lordship.
Next.
15. Please, Your
Hello.
Lordship. I'm sorry to say, my lordship, item number 29, my lordship, I missed out, my lordship, I was struck due to water logging, my lordship. LCR is here, my lord.
I've already adjourned for 2 weeks, so when do you want it? In item 29, the scan copy is there, case record is there, right?
Yes, my lord.
So all right, to Wednesday kore diok.
If possible today,
Wednesday.
before rising, my lord.
Wednesday.
Highly obliged, my lordship. I'm grateful, my lord.
Order to list চাই ল'বা।
Please, Lordship, anticipatory bail application, Lordship, case diary was called for. Allegations of murder are there.
Here also CD not received, my lord.
Await case diary, list on such and such date.
Small prayer. The allegation is that I assaulted the victim at my premises. So the CCTV report of the CCTV footage may be called for, Lordship. Injury
Along with CCTV footage,
If they have seized, my lord.
if available.
If available.
of my residence of the.
If CCTV footage of the place of occurrence,
Yes.
if available.
Highly obliged.
115.
May I please, Your Lordship? For a take a petition, my lord, and
CD,
page affair, page 8 is the affair, my lord. Kindly see, my lord.
rape,
My lord, may I read, my lord? Page 8, my lord.
yes. Page 8. Yes.
Here, one thing is there, my lord, CD we have received on 7/4. On 9/4, up to date CD was called for, my lord, but it was not taken back, my lord. CD is actually not up to date. CD with us, my lord.
Kindly see the affair, face of the affair, my lord. One married lady, my lord. lost-
No, but there is a judicial order. Updated case diary was called. It's not available.
We have sent the signal on 10/4, but it was not taken back, my lord. Only one.
You had not sent the case diary.
My lord, they have not come. We have sent the signal on 10/4.
Acha.
Police has not come to take.
Okay. It appears that the updated case diary as called for earlier by this court on 9/4/2025 is still awaited. List on issue reminder, list on such and such date.
My lord. Given a chance for recording my statement, my lord. First, my lord,
That
kindly see the affair, my lord.
It's all right. Next. 14.
Obliged.
40 to 42, 40, 41 and 42.
May I please, Your Lordship? I am appearing in item 40 and 42, Lordship. 42
Yes.
is regular bail application. Case day was called for,
Yes,
Lordship.
should be available.
This is 40,
40, 41 and 42, Lordship.
40, 41 and 42.
I am
And you are appearing in
40 and 42, Lordship.
I am
for 41, ma'am.
40 and 41 are AB. And
AB.
42 is a regular bail.
In 41, there is no
Interim, no interim.
41, there is no interim.
40, no interim. 41 is also no interim.
41,
Yes, I am.
interim is there. All right. So no, there is no interim.
No interim. And in 42, there is 72 days, Lordship.
72 days.
Lordship.
Yes. Which one are you, which brief?
Lordship, 40 may be taken.
40.
40, 40, 40,
Okay.
Lordship.
40 is AB 803.
803, Lordship.
Yes.
FIR is at page 10, Lordship, and XRA, Lordship.
FIR is at page
10.
10.
Long FIR, Lordship.
Yes.
May I read, Lordship?
Rupak, pani to the. Yes, please read.
May I read, Lordship? Text to state that on last 14/12/2024 at AM at night, it was informed from Nalbari Sarathi Hospital to Nalbari Police Station, police about mysterious death of Raghav Deka. The Nalbari police took over the dead body of Raghav Deka at about 3 AM and brought to Nalbari Shohid Mukund Kakuti Hospital for postmortem. But the dead body was handed over to the family members at 9 AM without postmortem. There is no entry on that day in the postmortem register of Shohid Mukundo Kakuti Hospital. It comes to knowledge that that the death of Raghav Deka was not natural, rather it is doubted that there was suicide due to love angle or consuming poison. It may be mentioned.
40 is the wife.
40 is the wife.
And 42 is taken loan.
Applied for loan, Lordship.
Applied for loan.
But could not
And
be
the other one?
Other one, the 41 is the
Petitioner in 41 is the cluster head of LIC Housing Finance Limited.
Cluster head
Yes, Lord.
of the
LIC Housing Finance Limited.
LIC housing. Okay. Now, what is the allegation in substance?
My lord,
One person have committed suicide.
one person committed suicide. From that my lord, incident, the whole thing come to the light. There in Nalbari, my lord, with giving fake documents, some loan provided to some persons, my lord, and this practice going on to submitting fake document and fake signature. There are statements of other some persons, Tilak Deka, my lord, for some instance, my lord, Tilak Deka, one Sanju Sharma and one Solen Sharma. They are the persons who ask persons, necessarily those persons give signature without verifying.
Who are those two persons?
Who are wanted to take loan or guarantor, all this, malad. So without verifying, malad, they have put the signature in all.
Now just tell me one thing. You see, because the person in item 3, the third item, that is 42, is already in custody since last 73 days. Do you further custody? I don't think is required for this. And as far as the 40 and 41 is concerned, they will appear. Let them appear before the
40 also his wife.
Is the wife, correct? The person who has taken is already in custody for the last 73 days. Right. I don't think further custodial interrogation is necessary.
Dipti Basha, her statement, statement is there, malad.
Who's?
Dipti Basha Deka.
Who is she?
Item 40.
Her statement is also taken.
Her statement also taken. Her statement in 183 statement also available.
So then
She
I
also
don't
said
think
that my husband want to take loan and Solen Sharma and one Sanju Sharma. They asked to put some signature.
I
and all.
don't think any.
But regarding 41 Nishan Anand, regarding that, malad, just I have gone through the city, malad, I have not yet received, malad, properly not yet verified, malad, regarding Nishan, malad. He is a person belong to LIC officer, malad. What is his role, malad? That has to, malad. I need only some time, my lord, just to.
All right, you
verify.
have a look at 41. Let me first dispose 40 and 42.
My lord, my lord.
Who is appearing in 40 and 42?
Lordship, I am appearing 40 and 42.
First, give me 42 first. I think two separate orders has to be only given.
My lord, yes, one is BA, one is AB.
A 42 to first. Heard, Mr. MK
Hussein.
Hussain, learned counsel for the petitioner, also heard Mr. KK Parashar, learned APP for the state respondent. This petition is filed under section 483 of the BNSS 2023, seeking regular bail to the petitioner, I. Tilak Deka, who is languishing, who was arrested on 15/2/2025 in connection with Nalbari PS case number 18/2025, registered under section 3162, 3165, 3182, 3184, 35 of BNS 2023, and added section 2061(2) of the BNS 2023. The brief facts of the prosecution case is that the FIR an FIR was lodged on 9/1/2025, alleging inter alia that certain LIC agents in collusion with official staff of LIC HFL Guwahati have been sanctioning illegal housing loan to customers by submitting fake documents, fake guarantors, and fake spouses, amongst other false information. Accordingly, a case was registered and the petitioner was arrested on 15/2/2025. Mr. So-and-so, learned counsel for the petitioner, submits that the petitioner has been arrested merely on suspicion, and therefore such arrest is in total violation of the law laid down by the Apex Court in Criminal Appeal number 621/2025 in the case of Bihan Kumar versus State of Haryana. Stop. He further submits that the petitioner is no way involved in the alleged offense and that he has been languishing in the jail since last 73 days.
72 days.
72 days. Stop. Per contra, Mr. KK Parashar, learned APP for the state respondent, submits that the case diary reveals that it is the petitioner who has taken loan by submitting fake documents.
Malat subsequently come to light, but regarding that, Malat one Sanju Sharma and one LIC officer, they put signatures and
has taken loan from the bank from the LIC housing
Finance Limited.
Finance Limited, wherefrom it appears that in the loan documents, two persons have put signature, forged have forged signature.
No, the two persons, Malat, give some documents to him to signature and without verifying.
Two persons who have signed the signed the loan papers in favor of the.
No, they give this Tilak Deka some documents, and Tilak Deka has put his signature without verifying this document.
Who is this person? Tilak Deka
is the petitioner, Malat.
I am the petitioner. I am the applicant, Lordship.
He has.
Show me where it is mentioned.
And in forwarding also, Lordship. Page
Where?
25.
Page
25, Lordship. Forwarding also.
That the accused person is actually a loan customer who by using deceptive means, including falsifying his wife's detail, had obtained loan. Huh? Stop. Heard, perused. It appears from the case diary that during investigation, it has come to light that the petitioner has submitted false and fabricated documents of another female person, falsely claiming her to be his wife, and applied for a housing loan from LIC Housing Finance Limited. Correct, Mr.
Madam.
And that he has confessed his guilt during investigation. It appears that there are no adverse antecedents available against the petitioner in the case diary. Stop. Considering that the petitioner has been languishing in the jail since last 72 days, this court is of the considered view that further detention of the petitioner is not justified. Accordingly, it is provided, this would be
CGM Nolbari.
satisfaction to DDBA, CGM Nolbari, baki those conditions. Bail bond of rupees?
Not less than 30,000, madam.
All right, 30,000. Good. Now, second case to the other case, going to answer.
Item 14.
40, পৰখিনি same থাকিব, খালি এইটো AB হৈ গ'ল, এইটো তুমি ক'বা, this is an application under section 482 of the BNSS. এইটো dispose হৈছে দেই. BNSS 2023 seeking grant of pre-arrest bail to the petitioner, i.e. Dipti Bosho Deka, in connection, who is apprehending arrest in connection with Nolbari PS case number 18/2025 under section 3162, 3165, 3182, 3184, 35 of BNS 2023 and added section 61(2) of BNS 2023. A brief facts of the case of Jasa. By one, আগৰ হেৰিটোৱে থবা, facts, brief facts to নে, and technical submission koba je Mr. So-and-so submits that the petitioner is neither the FIR named accused person nor involved in the alleged offense, and that she has been dragged into this case by the informant with a view to achieve aligned motive. Stop. Per contra, Mr. So-and-so submits that it appears from the statement of the petitioner recorded under section 183 of BNSS that she had put the signature in some papers as per direction of
two persons, one Sanju Sharma and one
person, namely
Sanju Sharma and
one please give those two names.
Sanju Sharma and Shailen Sharma.
Two persons, so and so, so and so. Stop. Submission at Koiriba. He further submits that the petitioner is ready and willing to cooperate with the investigation. Now, she has already given her statement. Anything required?
Only cooperate, Lordship.
Considering that the petitioner is not named in the FIR, and she has already, and her statement has also been recorded by the investigating officer, and that she is cooperating with the investigation, this court is of the considered opinion that her custodial interrogation is not justified. Accordingly, pre-arrest bail to, in the event of hearing, to
Arresting authority.
Arresting authority and bail bond of
20,000. 23.
All right.
Disposed of, both disposed of. 41, I'll come back in 5 minutes.
Person Nishan Anand, he is the cluster head, matlab the overall head. And his name has been given by the informant because of that Nalbari has given 80% of the matlab business, but because of that it was closed. It was closed because of this corruption.
His statement has not yet been taken.
No, not.
Let him appear. I'm giving him in bail.
From the petitioner, some document has been, as a cluster head, my lord, from the office, my lord, some document has already been seized, my lord, by police, my lord.
Some documents.
Yes, my lord.
But regarding directly like involvement is not there.
Sorry?
Direct involvement, my lord,
Is not there.
not.
Heard Mr. M. Saikyal, Learned Counsel for the petitioner. Stop. Also heard Mr. K. Parashar, Learned APP for the state respondent. This is an anticipatory bail application under section 482 of the BNSS 2023, seeking pre-arrest bail to the petitioner, i.e. Nishant
Anand.
A-N-A-N-A-N-D.
Double A, my lord.
Huh?
Double A.
Are you sure the spelling is correct?
Yes, correct, my lord. Double A.
A-N-A-N-D. Who is apprehending arrest in connection with Nalbari Police Station case number 18 of 2025, registered under section 3162, 3165, 3182, 3184, 35 of BNSS 2023. So, the brief facts of the case is that he agortue hobo. It is the same FIR, isn't it?
Same, my lord.
Agor FIR to ki likh dibo de. Mr. So-and-so, Learned Counsel for the petitioner, submits that the petitioner is presently working as cluster head of Assam and Tripura, posted in LIC Housing Finance Limited, which is the informant company.
No, my lord. Informant is, my lord,
Okay.
an agent, my lord.
All
whose
right.
Agency has terminated, my lord.
And he joined in the said office as area manager on 27/5/2022 and promoted to the said post of cluster head on 12/5/2023. Since the allegation made, he further submits that since the allegations made in the instant FIR and the anomalies referred therein is with regard to the loan accounts, which is not related to the petitioner in any way, the petitioner has been unnecessary. Have you been named in the FIR?
Yes, sir.
Named.
Name because this agency has been closed, my lord.
Has been unnecessarily dragged in the case. Stop. He further submits, per contra, Mr. So-and-so Learned APP submits that there is no materials in the case diary to indicate direct involvement of the petitioner in the alleged offense. Stop. Perused. It appears that the petitioner, who is the cluster head of the LIC Housing Finance Limited in question, was questioned in connection with the FIR in question on 31/2025, and 2 documents has already been seized from his possession. Stop. That apart, perusal of the case diary indicates no incriminating material at this stage against the petitioner. considering the, no, wait. It appears that the petitioner is cooperating with the investigation and has already is cooperating with the investigation. That being so, this court is of the considered opinion that custodial interrogation of the petitioner is not justified. Accordingly, it is provided. Hey, so and so koi diba. Agor anticipatory kiman dilu. Same, huh? But I think he has to appear.
Hello,
So, 10 days. Etu agor anticipatory local cooperate koriba or 8 to 10 days, huh? 11 date cancel ho jabo jodi nokore. Buji pala na? Disposed of. Forty-three. Yes, case diary. Yes. What is this?
FR page 8.
Page?
8.
Page 8.
Accused number 1, Lordship.
Yes, please read.
Take to state that yes, father rebuked his children for not staying. Morning at about 7. Called my mother, commute dust on this. Then my mother also. But before my mother, with an father moved aside. The result of which the ex and assaulted her back and hands by previous injuries, and immediately my mother fell on the ground. Then the accused number 2 came with a hook in his.
You are one. You are.
Lordship, I'm the accused number 1.
Injury report is has it expired? Huh? What is the case?
My injury report received here. The only thing is that here the nature of the injury, whether grievous, simple, that is not mentioned.
Why?
No, my lord, but otherwise injuries are explained.
How? What is the
Lacerated wound over the right angle of the mouth, loosening of the incision teeth of lower jaw, bleeding gum, scalp, hematoma over left temporal part, swelling around the left wrist, tenderarm over the right side of chest.
Is he on interim? No.
No, my lord. Otherwise, my lord, eyewitness statements are there, victim statement is also there. Actually, there are 2 persons. Allegations was against 2 persons. It seems by the other person there is nothing, but against him, my lord, there are specific
incriminating materials are there.
In fact, the victim, the injured lady, she also.
What does she say in her statement?
Let's see, I cannot read actually with all that.
It's in vernacular.
It's vernacular. No, I can read, madam.
Just. Oh, okay. It'll.
So, my lord, otherwise he assaulted with an X, my lord.
That is there. With an X. There was a fight between the 2 families for which the family members of the informant were sustained injuries. Stop. For contra, Mr. R.R. Kaushik, cleared APP, submits that the injury report as available in the case diary reveals that lacerated wounds of grave nature. Huh?
Lacerated wound over the right.
Lacerated wounds over the
right angle of the mouth.
Of the right angle of the mouth of
my lord.
Mother or brother?
Mother.
Of the mother is indicates indicates so and so on the face of the mother, and on the brother, nothing.
Well, only mother's injury report is here.
This is brothers.
Mothers.
Stop. It further appears that the allegation in the FIR is that the petitioner has hit the mother, not the that while the petitioner was aiming to hit the brother of the informant, he accidentally had hit the mother. It further appears that it is the other co-accused again whose the allegation is that he has hit the brother in the vital part of body, eye, head. Stop. এইটো তেওঁৰ সাবমিশনত কৈ আছো না
Not mine.
এইখিনি তুমি পিছত আনি দিবা তাৰ ওপৰত য'ত আৰ কৌশিক আছে সেই ইণ্ডিকেটছ হিৱান কৈ পেলাই ষ্টপ কৰি দিয়া হা ফৰ কন্ট্ৰা পেৰুজ কৰি দিলা দেন ইট এপিয়াৰ্ছ বুলি কৈ দিয়া তাৰপিছত লেখা যে considering the in her submission, you also write that she further submits that the petitioner is ready and willing to appear before the investigating officer and cooperate with the investigation. Now you say that it further appears that the case diary indicates that that the statements recorded during that the statement of the witnesses recorded by the investigating officer during investigation as available in the case diary reveals that the petitioner has hit the mother. Stop. Considering the totality and facts of the circumstances, and this court is of the considered opinion that the custodial interrogation of the petitioner may not be justified in the facts and circumstances of the case. Accordingly, it is provided. Yes, how much? Arresting authority, na? How much?
30,000.
30,000. Subject to condition, 10 days appear before the investigating officer, and the 2 and 3 disposed of.
Number 44 to 47.
Itu কিমান আছিল?
Please, Lord. Item number 44 and 45 are out of same FIR.
ইয়াক চেঞ্জ কৰি দিব, he's got বহুত গিটা পাইছে না? Yes.
Item number 44 and 45 are out of same FIR.
40
and 45. No, FIR is registered by
44 and 45 is
same FIR.
CD available?
Yes, Your Lordship. CD is available.
No.
Yeah.
FIR was registered on the basis of LSD on the basis of source information. Lordship, page 16, the contents is 20 at page 20.
Yes.
I please read.
Yes.
Paragraph 12. A reliable source information has been received to the fact that Pinku Kumar, manager scale 3, while working as branch manager of State Bank of India, Ramkishanagar branch, Karimnagar, Assam, in conspiracy with middleman Sri Shuman Pal, disbursed express credit loans to various borrowers during the period 2023 to 2024 in view of undue advantage bribe, which were collected by Sri Shuman Pal and unknown others.
What?
I am in this case Shuman Pal.
Shuman Pal.
45. In 45, Pinku Kumar.
Yes.
Information further alleged that the undue advantage bribe of total rupees 40.95 lakhs approx were collected by middlemen Sri Shuman Pal and in conspiracy with Sri Pinku Kumar and unknown others, and thereafter Sri Shuman Pal credited an amount of rupees 12.10 lakh approx in the bank account number such and such of Sri Pinku Kumar with Canara Bank, and remaining amount of rupees 28.85 lakhs approx in the bank account number such and such of Sri.
This is anticipatory.
Anticipatory. Lordship,
the allegations are serious.
yes, there are some explanation, Lordship, if I may, Lordship.
You see, if it was a bail application, there was no difficulty. But
May I please
yes, what is the what are the materials in the CD?
Yes, material in the CD, it is found that there is a transaction with the manager and the middleman. Various transactions are there, and some UPI transactions are also there, which is still required to be retrieved. It is at the very initial stage, and investigation is yet yet not completed.
I am,
So, and not only that, during the course of seizure and search, more or less half kg of golds are found. And to that effect,
Half kg golds found from where?
from the house of the wife of
Pinku Kumar.
Pinku Kumar. And there is a various transaction. It is given in the CD with the Suleiman and SBI, Canara Bank, and also the
These transactions are between
the manager, bank manager, and the middleman.
manager is
we are admitting Lordship all transactions.
Manager is Pinku Kumar.
Pinku Kumar.
We are admitting
So
transactions.
there are incriminating evidence.
Incriminating. And
Mr. Counsel, this is not a case for anticipatory bail.
Lordship, for a few moments, Lordship, for a few moments, there are documents, and those documents were seized by the CBI also.
All right. You
Now-
see, ultimately, it's a discretionary.
Yes.
This
If I
court
may,
is
Lordship.
not.
their
Allegation,
names are there,
transaction.
FIR. Why for
Investigation is at a very crucial stage.
No, why these transactions, Lordship? I am just trying to.
How can this court go into all that?
No, these are also
These
seized.
are the
I will. We will.
Mr. Purkasta,
Lordship.
the investigation is at a crucial stage. This
Yes.
court cannot go into the defense that you are taking about
No,
these transactions.
these-
Admittedly, there are transactions and the amount is huge.
Lordship, these are not one go, Lordship. There are allegations that there are express credit loans which are always given to the government employees, or while giving those loans, bribes been taken. But they have during search seized certain documents from Pinku Kumar, and these I have also annexed.
Yeah.
Now, why this Suman Pal paid this amount to this Pinku Kumar and his wife, Lordship? Lordship may kindly come to page 27. There is a sale agreement. There was a proposal for purchasing of land of Pinku Kumar, and against that, on several dates, these total
How this court can go into all this?
these were seized by Lordship, seized by them.
But even the
These were-
NJ paper.
We will
does
explain
not
them. We will
reflect the
cooperate with the
backside.
investigation.
Side of the NJ paper does not reflect that when it was issued.
Give me the case there.
Yes.
And what happened, Lordship, subsequently? Lordship, may I please add
Various
two
transactions and
lines,
books are
Lordship?
there, which were subsequently recovered before the filing of this objection. That is why in this objection, it was not incorporated.
Where?
Those things which are recovered subsequently, that is after the filing of objection. Otherwise, we could have incorporated
You have
all
filed
this.
an affidavit in opposition.
Yes, Your Lord. And we could not able to
Subsequently,
incorporate.
Lordship, these
And still investigation is going on. There are many unknown person. And huge transaction.
One
are there.
second. Let me go through. Very nice, Ji. Huh? It's at a very crucial stage. The remaining documents which has
Lordship,
been
if I may
seized
submit my
is yet
part,
to
Lordship.
be scrutinized.
I beg to submit my part, Lordship, because those are also seized. In this case, Lordship, the agreement for sale subsequently failed because the petitioner resigned from the contract and issued a letter to the wife of the petitioner, who was the seller in that agreement, saying that he is not willing to proceed further and demanded this 41 lakhs.
Mr. Counsel, are these not factual matters? Are these not matters which has to be ultimately taken up at the time of trial?
No, Lordship, these are seized documents. It's not my document. These are already has become prosecution documents. In this search list, they have in the item number 45, there is a search memo. They have seized all those documents, Lordship. And thereafter, Lordship, I issued thereafter in this case, this petitioner issued a legal notice to this wife of the wife of this Pinku Kumar, demanding this 41 lakh back.
No, who had issued a legal notice?
Petitioner of this case.
Tinku.
No, Shumen Pal.
He issued.
He issued. He resigned from the contract that it is some problem. So
You are representing both.
yes, both, representing both. Because
He is from Silchar. Person
Because-
is from Silchar. Why he will enter into agreement for a sale of land in Bihar?
and I have
That
not
is
completed
also-
this. Thereafter, Lordship, all the amounts have been 41 lakh has been refunded to this petitioner. I have annexed the statement of account also from the account of the wife of the petitioner. These were the installment amount, advance amount for purchasing the land. This is the explanation in this case, Lordship.
All right, I'm going to take this matter to tomorrow and let the CD be here. Item numbers, the details. This CD is in respect of all the matters?
No, another city is there, CD is there.
Who is appearing in that? You're appearing?
Yes, I am appearing. Lordship.
Please give the case diary.
Yes.
Let me have a look at it.
44, 45, and this is for 46.
There are explanations, Lordship. That's why their custodial information
Heard
is
in
not
brief, MS so-and-so, learned, you're appearing as special prosecutor?
Yes, retainer counsel of the
Retainer counsel of
CBI.
CBI submits the case diary as available. Case diary of the case, which is relist on such and such date. Tomorrow,
all the cases.
it will be turned into the case diary.
Yeah, I have checked, probably your lordship can take up this matter because here lordship, Honorable Justice M.R. Pathak once rejected one co-accused bail application and he is not taking up that bail matters. And one application was previously rejected and subsequently allowed by Honorable Mr. Justice Susmita Khan lordship. And that bench is also not taking up regular bail matters.
What about the
Present petitioner is coming for first time lordship.
No, but there is also a connected case which was disposed by Justice Robin Foucan, which
But that
bench is
bench also
available.
not taking up the criminal bench.
Maybe equal.
As per High Court notification, lordship.
Ticketer otherwise আছে গুৱাহাটীত notification খন ক'ত আছে? Is it, have you seen that new notification, Mr.
Yes.
Kaushik?
I have little forgotten, but the thing is that my lords, some cases, criminal cases, which are earlier rejected or dealt with, not this matter, but some matters are court number 12 is taking up, my lord.
Court number 12?
It's taking up those matters. My lord.
And this matter is
This
connected.
matter, my lord, because I think, my lord, that regarding this petitioner, my lord, it has come for the first time.
But in connection with the same FIR,
Yes.
Court 12 has taken
Has taken earlier, my lord.
and is available.
Otherwise available.
So then it should be listed before the appropriate bench.
Oh, here just I am.
Only I think when that bench is not available, that is where the modification has come.
Yes, that is
Isn't
the
it?
notification number 12 of 2025, dated 12 February
Can you
2025.
read it?
Yes, Lord.
And please give a copy also. It 30%, it লৈ আছা নহয়? Yes.
If bail applications are assigned to different single judges bench, in that event, all the applications arising out of same affair will be placed before one honorable judge for disposal. Number 2, all bail applications arising out of the same FIR which are filed in the Guwahati High Court are to be listed before the same honorable judge who has previously disposed of bail applications pertaining to same defiant accused persons of the same FIR only if the said honorable judge is taking up bail matters as per roster. However, in the event the honorable judge is sitting in a division bench or is not holding the criminal roster or is stationed in a different state under the jurisdiction of the Guwahati High Court, the instant direction would not be applicable. So that direction will not be applicable if it is not in the roster.
Justice Khan and Justice Pathak are not in station.
No, Justice Khan is not in station and Justice Pathak is not taking up the bail matters as per roster.
Right. And Justice Fukan is also, I think, taking a civil bench,
Civil
right?
benches.
All right, then I think there is no
Then is
difficulty.
no.
Okay. Yes.
Primary ground is that not communication of the grounds at the time of arrest, Lordship.
Is that the ground taken?
And other ground is also there that she is in custody, Lordship.
That is the ground, then I don't think the other grounds are required also. Where have you?
But actually, my learned friend KK Parasar has gone through the scan.
There are
today.
two.
But otherwise, I have also checked, my lord, regarding that grounds of arrest, it has not been mentioned.
It has not been mentioned.
Factually, I have not seen.
Yeah.
Actually, I have not gone to the record.
But I'm only going to dispose it of on that.
Otherwise,
What is Mr. Parashar is not there
he is on legs in a different court.
at 2?
At 2 minutes.
At 2. Because let Mr. Parashar be here.
Otherwise, not taken.
But I just need to see from the arrest memo and the inspection memo if it is available.
I have filed additional affidavit to bring on record, Lordship.
It is there.
It is there.
Which page?
Page 55, Lordship. Running page 55. 55 and 56.
Five. So just reference of the provision, nothing else. Right.
General, that is.
All right. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned APP for the state respondent. This bail application is filed under section 483 of the BNSS 2023, seeking grant of regular bail to the petitioner, i.e. Srimati Geetashri Sinha, who has been arrested on 16/10/2023 in connection with Sessions Case number 51 of 2024, arising out of Bokhista PS case number 621/2023, registered under section 120B302 of IPC, read with section 25(1)A, 27(1)A of Arms Act, which is pending in the court of Additional Session Judge 2 Kamrup M. Guwahati. Pending trial, which is pending trial. Huh? Stop. So you've been in custody since?
For 1 year, 6 months, 13 days.
1 year?
6 months.
6 months?
13 days.
13 days. The facts of the case is that an FIR was filed on 13/10/2023, alleging inter alia that on 12/10/2023, at about 8 p.m., some miscreants coming in two-wheelers motorcycle shot the brother of the informant, i.e. Anjan Nath, while he was sitting on a bike near Khanapara Ganesh Mandir, and after being admitted in the nearby hospital, he was declared dead by the doctors at the hospital. It is the alleged case of the prosecution that the petitioner, who is the sister-in-law of the informant, along with her mother, former husband, along with some others, are suspected to have shot dead the informant's brother in a planned manner. Accordingly, a case was registered and the petitioner was arrested. So, Mr. A. Ahmed, learned counsel for the petitioner, submits that the petitioner has been, that the arrest of the petitioner is totally illegal and invalid inasmuch as the arresting authorities has not informed the petitioner the grounds of arrest at the time of her arrest. He accordingly submits that the petitioner's constitutional and fundamental rights having been violated by the arresting authority, the petitioner is entitled to be released forthwith. He further submits that the petitioner has been wrongly and illegally detained since last 1 year, 6 months, 13 days. Stop. Per contra, Mr. R.R. Kaushik, learned APP for the state respondent, submits that the allegations are grave in nature. Trial is going on, and the trial is going on wherein how many witnesses?
Only Lordship, charges are framed and no
Wherein,
witnesses examined. After
wherein
60
charges have been framed. However, no witnesses till date has been examined.
out of 60 witnesses.
Let me not put that in his words.
Yes. I have not checked that angle.
Wait, that I will do it. He further fairly submits that the arrest memo and the notice issued under section 50 of CRPC does not indicate the grounds of arrest being informed to the petitioner at the time of her arrest. Heard, perused, it appears that the primary ground for bail urged in the instant bail application is non-compliance of the constitutional mandatory obligation enshrined under Article 22(1) of the Constitution of India by the arresting authority. Apt to refer to Article 22(1) of the Constitution of India, which reads as hereunder, quote unquote. A perusal of the aforesaid article, it is abundantly clear that the arrestee has a constitutional and fundamental right to be informed of the grounds of his/her arrest by the arresting authority at the time of such arrest. Any violation of such procedure would vitiate, would infringe the very constitutional and fundamental right guaranteed to the arrestee by the Constitution of India. Stop. A perusal, which page?
Page 55 and 56.
Page 55, na? Apt to refer to the notice issued to the petitioner under section 50 of CRPC, which reads as hereunder, quote unquote, page 55, A to A. Okay. A perusal of the aforesaid notice indicates that except reference of the provision of the section of IPC and the Arms Act, no other information is provided in the said notice. Apt also to refer to the arrest and inspection memo, which reads as hereunder, quote unquote, page 56, A to A. A perusal of the aforesaid arrest and inspection memo also indicates that except the case reference number, comma, name and address of arrested person, comma, date and time of arrest, comma, no other information as regards the offense, alleged offense is available in the said arrest and inspection memo. In view of the aforesaid, it is abundantly clear that apart a close perusal of the materials available in the case diary further indicates that there is no materials whatsoever available in the case diary to indicate that the arresting authority has informed the petitioner the grounds of her arrest at the time of her arrest.
In writing.
I am not going to go into that. That is, when that point is urged, we will consider that point. Stop. That being so, it is clear that the arrest of the petitioner is totally illegal and is in violation of the constitutional safeguards guaranteed under the Constitution of India. Hence, further detention, hence the arrest is totally vitiated. That apart, the petitioner has been languishing in jail since last 1 year, 6 months, 13 days. Considering the totality of so and so, this court is of the considered opinion that the petitioner is liable to be released forthwith upon a bail bond of
Earlier cases in 50,000 was fixed, Lordship.
50,000. Where is that? There is an order.
Lordship.
Where?
Page 45, Lordship, and relevant was page 47.
50,000 are suitable surety of like amount to the satisfaction of the learned trial court under the conditions 1, 2, 3 Didiba shall cooperate with the trial. Number 2, not to leave the jurisdiction of the court without prior permission till completion of trial. And number 3, petitioner shall not petitioner shall not exercise threats to the witnesses or try to influence the witness. On breach of any of the bail conditions, the jurisdictional court is at liberty to immediately cancel the bail granted to the petitioner. In terms of the above observation, bail application stands disposed of.
Obliged.
Disposed of the 40? 49. Yes, Mr. Biswas.
My lord, this bail application, I am urging 4 grounds, my lord, and each one of ground on its own is sufficient, my lord, to get a bail.
One of your primary ground was that the person is languishing since last 4 years, 1 month, 13 days.
Absolutely.
And you have cited a decision of the apex court wherein it says that
3.5 years, section
Yes.
37 condition can be dispensed with. In
Mr. Kyle, have you seen this decision?
Yes, Lordship.
What do you have to say?
Lordship, here, he was arrested. Lordship, please to see the stage of the trial. He was arrested on 17/3/2021. And initially he was found to be absconder when the complaint was filed. Subsequently, he was arrested. And Lordship, out of 10 witnesses, 5 were examined. All official witnesses were examined. 5 witnesses, Lordship, 3 are independent witness, 2 are the official witness of this Airtel and others, Lordship. Summon has been issued, and next date is fixed on 8/5/2024.
Only thing is that there has been a prolonged incarceration.
So whether it can be a ground in case of NDPS, Lordship.
Yes, this decision.
My humble
There
submission.
is a decision of the apex court.
Lordship, another case, I'm relying on one judgment. Paragraph 39 of this Kasib judgment. Is that not the simple offense, Lordship?
Correct, but in fact, this was the first thing this court had asked, and Mr. Biswas had cited this decision.
Paragraph 39.
Paragraph?
39. paragraph 1 and 2.
39.
Yes, please.
The object of the above discussion may be summarized as under. The provision of NDPS Act are required to be interpreted keeping in mind the scheme, object and purpose of the Act, as also the impact on the society as a whole. It is to be interpreted literally, not liberally, which may ultimately frustrate the object, purpose of the preamble of the Act. Then 2. While considering the application for bail, the court must bear in mind the provision of Section 37 of NDPS Act, which are mandatory in nature. Recording of finding as mandated in Section 37 is sine qua non, is known for granting bail to the accused involved in the offence under NDPS.
The only thing is, Mr. I have seen any lapse or delay in compliance. That is different. But where have they said about the delay of the trial?
That has not been considered.
Correct. You see, this is a in this decision, this aspect has been gone into by the apex court. As regards to the twin conditions contained in Section 37 of the NDPS Act, learned counsel for the respondent state has been duly heard. Thus, the first condition stands complied with. So far as the second condition reference formation of opinion as to whether there are reasonable grounds to believe that the petitioner is not guilty, the same may not be formed at this stage when he has already spent more than 3.5 years in custody. The prolonged incarceration generally militates against the most precious fundamental right guaranteed under Article 21 of the Constitution, and in such a situation, the conditional liberty must override the statutory embargo created under Section 37(1)(b)(2) of the NDPS Act.
Now question will arise, which time period will be considered as a long incarceration, Lordship?
Yes, 4 years. 4 years, 1 year, 1 month, 13 days.
Yeah, Lordship, it is not correct because he was arrested in 21 in the application.
All right, 2. Please have the, this is submitted by you. Arrested on 16/3/2021, you're disputing to that date.
No, Lordship, in application, they have written some other date.
No, that was a typographical error. This is the correct.
Mr. Kayal, you have the records, please
No,
verify.
17.3 is correct, Lordship. I'm not disputing
63.
because
Then number of days would be 4 years, 1 month and 13 days.
I have not been supplied with the copy of that, so I'm not aware whether because I am going by.
You have a look at it and see if if the records indicate that the days are as indicated by Mr. Biswas.
It is correct, Lord. It is
So
correct.
in that situation, you see, I am bound by this decision.
No, Lordship, it is correct, but Lordship is to consider whether Supreme Court has given any fix any period that to be considered.
Nothing. But in that case, it was 3 years, and here it is 4 years.
No, Lordship, here for the first time, Supreme Court in case of Satyam until said that in case of NDPS, 436 capital will be applicable.
Yes, Mr. Kayal.
By submitting, there is no concrete definition with regard to period which can be considered as.
There is no dispute, but you see the decision which has been placed before this court. In that, the period was 3 years something, right?
I'll come to that.
And in the present case, it is not. At the end of the day, it is the discretion of the court.
Yeah, definitely.
Correct.
I'm not on.
So now, if you because you see, we cannot. This court is bound by the ratio of that decision.
Lordship, I'm not disputing everything, Lordship.
Then
I'm just placing the law. Lordship, that has been explained in 436 capital A. 436 capital of CRPC. I'm not questioning your Lordship discretion and other points to be considered, your Lordship. I'm placing the law. I'm assisting your Lordship.
Yes, yes.
436 capital A.
Yes.
Minimum period for which an under trial can be detained.
Minimum or maximum?
Maximum.
Can be detained. Maximum period.
Maximum
Period for which. Where a person has during the period of investigation, inquiry or trial under the code of an offence under any law, not being an offence for which the punishment is death has been specified as one of the punishment undergone detention for a period extending up to 1/2 of the maximum period of imprisonment. Your lordship, it is stated that maximum period of the and the half of that, lordship. Here in case of NDPS, lordship, maximum punishment is 20 years, lordship. If you go by that, by dictation of this section, then minimum 10 years will be there, lordship. Lordship, in case of that Ravi Prakash judgment, lordship, paragraph 3.
Lord, I'll answer to this.
1 second, please.
In the new act, lordship, same has been reiterated.
In computing the period of detention under this section for granting bail, the period of detention passed due to delay in proceeding caused by the accused shall be excluded. Achha, that is not applicable. You see, Mr. Counsel, 436A, all right, it says that maximum period for which an under trial prisoner can be detained.
Yes, lord.
No difficulty. Now here it's an obligation that if a person has been detained in custody for more than 1/2 of the maximum period.
Yes.
Suppose 20 years, 11 years.
Yes, 10 years.
Then
Can put 10 years.
more than correct. So then automatically he's entitled to be released. There is no question of any discretion here. This is, please hear me out. This is the law as per section 436 capital A of the CRP. Now, in a given situation, and that too in a case of an NDPS, the apex court has considered that this long delay of the trial and considering that a person has been languishing in jail for more than 3 years itself is sufficient for the rigors of section 37 to not come in.
That is for particular case, lordship, here.
Correct. Now,
paragraph 3 of that judgment.
I don't find any reason for not accepting that proposition.
No, lordship, correct, lordship.
Of the law which the apex court has laid down.
Lordship, one law has
In
been.
this case also it is more than 4 years. And that is why I said that discretion can be used.
Yes,
yes.
Not on that, lordship. Lordship may come to page paragraph 3 of that particular judgment, lordship.
Of which judgment?
Ravi Prakash, sir. Ravi Prakash.
Huh?
Ravi Prakash.
Paragraph 3.
One petition is relying.
Yes.
Paragraph 3.
Yes.
We are informed that the trial has commenced, but only 1 out of 19 witnesses is an examined.
That only, you see, Mr. Kayal, I am appreciating your arguments, but you see, just because in that 1 out of 19 has been examined.
That is the main reason.
That is not the main reason. The main reason is that conclusion of the trial will thus take some more time.
Yes.
It could be of many things. Now, it could be a case where there are 19 witnesses and only 5 has been examined. That could also be. Here there are 10, only 5 has been examined.
Yes.
And that also for such a long period of time.
No, we have explanation to that also. For consideration by lordship. Lordship may consider or may not consider. Because probably record has already been called for by the lordship. So everything will be clear. Whether who is responsible for that, I'm not going on that.
So that we are not on.
Here, lordship, 10 out of 10 witnesses, 5 been examined. All official witnesses have been examined. Even IO has been examined also. Yet 5 witnesses are there. Out of 5, 2 are from the lordship that Airtel and others. And from that agencies for where the data has to be proved. That and 1 witness is relating to probably he was made accident, so he was unnecessary made a witness. Out of 2 lordship on 2 independent witness notice has been issued, but they didn't turn up. So probably that will be also be closed. Only there remains 2 witnesses, lordship. So here in this case, out of 10 witnesses, 5 will already official witnesses have already been examined. So case of the Viprakash is not made applicable in this case also, lords. To my humble submission. Otherwise, law is very clear, lords.
And out of the 5, you said official witnesses have been examined.
Five have been
And
accepted.
who are the remaining 5 witnesses? Have you said somewhere?
It is not.
Have
here.
you filed any affidavit?
No,
No.
Lordship, we have not filed.
So you give a piece of paper, you indicate this information. I'll take it up tomorrow.
Lordship.
My lord, I was just.
Mr. Biswas, you give your submission, whatever you have to say, give tomorrow. Mr. Kanal, you see, you just provide me that information.
Yes, yes, Lord.
All right. Who are the people and also from when the trial started
Yes.
and in how many period these 5 witnesses have been? I need this information.
Yes, I'll give.
If your lordship, my lord, kindly take up, it is there it is there in my bail petition, my lord. That is what I was trying to.
You indicate it because here it is not given. You may furnish another note where you may incorporate these informations. I'll take it up tomorrow.
But my lord, tomorrow at least at a fixed time, my lord, because today also morning, my lord, entire day I was waiting, my lord. At least
So,
fixed
Mr.
time.
Biswas?
No, my lord, because
So,
every
Mr.
time,
Biswas?
my lord, they are every time, my lord.
They are not taking time. Mr. Biswas, kindly don't make such submissions. Please
Lordship,
don't
enough is
make
enough,
all
Lord.
of this. Please don't make these kind of submission in this court.
Every time, my lord, when the matter is called.
Please don't make such submission before this court.
I have many things to submit, Lordship. My learned friend submit.
Mr. Kal,
Lordship.
that's all right. You give me that note
Yes, sir.
tomorrow. You
Yes.
want to refurnish any other note, and you are free to do it by tomorrow.
Lordship, I'll give. Much better.
Yes.
Behind bar 3 years, 10 days, minimum. Out of 25.
3 years,
10 days.
3 years, 10 days.
As on today. minimum. And out of 25 witnesses, only 6 witnesses already examined.
It is decision, একটা decision আছে 2 পেজৰ এটা আৰু এটা কপি কৰি মোক দিয়কচোন সেই ফাইলটোতে আছে এটা কপি কৰি দিয়কচোন yes out of
25.
Out of 25
Only 6.
6 only.
Only 6 examined. On the last
What is the offense?
offense, Milord, under section 151.
Unlawful.
Yes, unlawful activity.
ইয়াত লৈছো but ইয়াত থৈ দিব লাগিব yes I think only on this ground.
My lord, my submission is that, my lord, material witness not examined yet, my lord. My lord, out of 6, my lord, first one is, my lord, PW, one is, my lord.
No, but see, I'm not on that. 3 years, 10 days have gone.
My lord, if lordship goes through the entire record, my lord, it is a yes case, my lord.
Yes,
Because-
but for so long they have been inside. Out of 25, only 6.
Yes.
It's proceeding in a very slow speed. You want to rely on that same section.
My lord.
RPC 436 capital A.
My lord, that, my lord, definitely will come, my lord. And my lord, the section, my lord, attributed, and my lord, that is under search sheet also filed under under this section, my lord. And that's 17, 18, 18B, 19, 20.
What is, let us read the offense once.
UAP Act, my lord.
FIR.
Chapter space 15 million. I am reading.
Yes.
Based on credible input and backed by tech in regarding activities of a model of an important jihadi outfit based in Bangladesh and operating in Bhopal, Madhya Pradesh, Borpeta and Bongaigaon district of Assam. An inquiry was conducted by Jugigopa PS case number so GD number so dated so and also during local inquiries, it was found that a model of Ansarul Bangla team, ABT.
Who are you?
I am belong to Tripura, Milord. I am a general member, Milord, general person, Milord. He has no connection with the Jugigopa PS case, Milord. And he is arrested in connection with the Borpeta PS case, Milord.
That case, he has convicted 6 months, my lord. I have annexed this.
Right, continue reading.
Yes. my lord. It's a ABT having affiliation to Al Qaeda in the Indian subcontinent, which is active in Borpeta and Bongaigaon district of Assam, which is being led by Saiful Islam, Harun Rashid, alias Harun Rashid, Muhammad Saman, son of Swenso, village Swenso, district in Nayarganj, Bangladesh, a citizen of Bangladesh who had entered the country illegally and was working as an Arabic teacher in Dhakalaipara Madrasa Borpeta. After his arrest, he was interrogated by a team Bongaigaon DSB branch, and from local input it is learned that in July 2021, one Johuruddin alias Ibrahim alias Selim alias Oliullah Milan Swenso Milan PS Gopalganj, Bangladesh, illegally entered India through Agartala. He was received by one person, namely Sultan, at New Bongaigaon station.
Your name is what?
Imran.
Imran Hussain.
My name is Imran.
Figured Imran.
Yes, my lord. Subsequently.
A subsequent. Okay.
So. Hamid Ali. Hamid Ali, son of Asmat Ali. Tripura Hamaha.
Number 3 at the name of accused.
Yes.
But
I mean,
while narrating the incident, his name was not mentioned.
Later on, my lord.
Later
on, he is a active member of that, my lord, unlawful organization. And my lord, actively doing, my lord, all these things, my lord.
But his name is otherwise not mentioned in the
My lord, kindly,
allegations.
because my lord, material witnesses yet to be examined, my lord. I may refer, my lord, the rejection, it is earlier rejected by the special NIA court, my lord. Kindly come to, my lord, page 17, my lord, in the petition, my lord. In the petition, my lord.
Nia already convicted.
Yes.
And Nia court already.
There is, because, my lord, based on, my lord, case diary and, my lord, charge sheet, my lord, it is rejected. Particularly that's para 14, my lord. Page 20, my lord.
14.
Yes, my lord. Para 14, page 20, my lord.
Yes.
My lord, may I read, my lord?
Yes.
As per the charge sheet, the allegation against 8 and A9. A9 is the, my lord, present petitioner. Is that the accused A8 voluntarily joined and became active member of ABT module on the invitation of such and such, and the accused I am skipping, my lord, right? And A9 held A9, that is the present petitioner, my lord, held at Dharalipara village, Dhakaliapara village, organized by A1 and Mehboob Alam.
So he attended a training.
He attended the training, my lord. Then, my lord, he actively organizing the camps and other, and my lord, translating the all jihadi, my lord, publications in Assamese language, and it distributed among the youths in that locality, my lord. And my lord, not only this case, my lord, earlier also, my lord, is a Borpeta, another Borpeta PS case was also against them, but he is habitual in this regard, my lord. And my lord, kindly let examine the, my lord, material witnesses. My lord, it is 25. And my lord, now it is only 6, my lord. That some, my lord, trial may progress, my lord. But at this stage, my lord, if lordship intervene, then my lord, then thereafter, my lord, they interfere with my lord in other witnesses.
Yes.
Yes. My lord, kindly come, the UAP Act, my lord, the section 43D, my lord. D.
43D not.
And my lord, subsection 5 and 6. Yes. 43D5, my lord. UAP. And in regard to, my lord, half
One
of
second,
the, my
one
lord,
second.
conviction period, my lord, that is also, my lord, in 18, my lord, section 18, under section 18, my lord, it is life imprisonment. D5, my lord, may I read, my?
One second.
Madam.
the co-accused have already been sentenced.
My lord.
Huh?
My lord. The conviction is, no?
Yes, conviction, yes, my lord.
Yes.
Petitioner already convicted 6 months, my lord.
Petitioner also?
Page 23.
Page
23.
23.
how much? How many months? 6 months.
Oh, already served. my lord.
That is served.
My lord, in this case, my lord, two
Okay.
FIR named accused persons already.
This is in relation to the other case. This conviction is in relation to which case?
Borpeta PS.
Borpeta,
Borpeta,
another case.
In another
In
case.
another- This is Jogi
Yeah,
Gopal, my lord.
So on the basis of this, you are showing that he is an habitual offender.
Yes, he is habitual offender.
Same offense, my lord.
Same.
Correct. That is what it shows that you are habitually involved. You've been convicted. Despite that, you are repeating.
And my lord, already two accused persons, FIR named co-accused, my lord, already granted bail by the court below.
Who has been granted bail?
By the learned court below. my lord.
Who has been granted bail?
Court below. Court below. Subordinate. My lord.
Mr. Parashar, sorry, Sharma, at page 20, this is part of that judgment, Borpeta case.
Yes, my lord. My lord, I am showing, my lord, there is a.
But in this case, what is the allegation against him?
He's a, my lord, same kind of offense, my lord. Same
No,
kind of, my lord, he is.
No, Mr.
He is, my
Sharma,
lord.
I have understood that in case of Borpeta also similar thing. But as far as the present case is concerned, where is the allegation about him?
My lord, kindly PW1, my lord, kindly have a look at the PW.
Where do I get it? Because you're following what I'm asking.
Yes, yes.
Because in the FIR, his name is not set. Subsequently, it seems his name has been added.
Yes.
Now, on what is the material that you have got as far as he is concerned?
Yes, ma'am.
Borpeta case, I have understood. He seems well. For that, he's already convicted.
Yes, yes,
You
yes.
cannot convict him for that, isn't
Yes,
it? That
yes.
undergoing training,
Yes.
you can now
But
there cannot
kindly-
be another conviction for the same thing.
Yes.
So here, what have you found against him?
You kindly come up on PWD1, my lord, statement of
So,
PWD1, my lord. The record, my lord. I have.
You followed what I'm asking,
Yes,
right?
yes, my lord. That is the separate case, my lord.
Correct.
This is Jogi
That
Gopal, my
I
lord.
take care
Yes,
of.
yes.
But I want to know in this case, what is there against him?
Sufficient material. The first part, my lord. First one, my lord. First one, my lord. The above one, yes, my lord. It is.
This one, the first one?
Yes, my lord.
Yes. Yes. What is his name?
Imran Hussain, my lord.
This is Ken, na?
My lord.
It appears that it is the same allegation here also.
My lord, same thing he is repeating, my lord.
This
Same,
is in a
and my lord,
different place.
yes, my lord. Yes, my lord, this is a my lord, very organized way, my lord. They are doing this, my lord, in that part of that land, my lord. And
2, 3, 4, 5, and 6. my lord. They are not.
Okay, I'll consider. Let us have this matter fixed again on Thursday. Let me think of.
Or maybe part.
Jogi Bhoppa,
And also matter maybe part.
This is the only bench taking up special act. It's under a special act.
pardon maybe.
Maybe part.
Maybe parted, that may be kept parted. No.
Heard Mr.
Yeah, ma'am.
So and so learned counsel for the petitioner also heard Mr. P.
P, sir.
B. I get confused with the initials.
Yes.
B is there.
Yes, my lord.
And
There are
you are
3B.
B. Yes.
There are 3B.
That's what There is another Sharma, isn't it? He is.
He is Bidyut Sharma, I am Bankim Sharma, he is Bhaskar Sharma.
It's three or P? B.
B.
You are Vidyut.
I am Bankim.
Bankim. You are Bhaskar. And he is Vidyut.
He is Bidyut.
He's the junior B, most probably.
He is a junior B.
I think we'll have to identify you all in that manner. Also heard B. Sharma and at APP for the state respondent. Upon hearing the matter in for some time, don't say that. List the matter for further hearing on such and such date. It will not pelai dibo ha. It will Wednesday ever sabole. Further hearing. Hey, decision to hear.
Number 26.
26 to hoi jua nai niki?
Actually, Mode 83 of BNSS. Find the bar for last 56 days.
56.
Days. Now
Statutory period?
60 days.
60.
Offenses under section 303, subsection 2 of BNS and section 21B and 29 of NDPS.
Up to date case diary is available, Mr.
Yes,
Sharma?
Lordship. Yes, Lordship. FSL report is not yet received, Lordship.
FSL?
Yes.
Injuries?
No, Lordship, regarding the contraventions, Lordship.
Oh, this is what, NDPS?
NDPS 21B and 29.
Then I think it's better to have it.
56 days today, Lordship.
Lordship, 60
Hmm?
days.
60 days is the mandatory period, Lordship. So let
And
it be
that
after
and
2 or 3 days.
56 days.
Huh?
After 2 or 3 days, Lordship. Possible.
So what is to be done?
I may be allowed to send back the CD for FSL report, Lordship.
But FSL at this stage, 56 days.
Because C is there. C is there.
B.
Huh? B.
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 Intermediate, Lordship.
Intermediate quantity. And no earlier criminal background, and I am a petition one is
Yes, antecedents?
No, Lordship.
No.
We are West speaker here. India.
No, if you say, because I've already given bail in a similar situation, I think 59 days that was.
Yes.
And all that also intermediate quantity.
To be honest, Lordship, if it had been ganja, Lordship, probably I would not have stated anything, Lordship. But Lordship, regarding heroin, Lordship, cannot.
Conscious.
Where is the FIR?
Is that phase
10.
But that report is not there till now.
Yes, FSL report has not
It's
been-
still not come.
Yes, yes.
FIR is at page?
Phase 14, Lordship.
This was seized from his possession.
From the house, Lordship.
You are Abdul Haq.
Abdul Haq and another.
Are you Abdul Haq?
Yes. There are two petitioners and Sofikul Islam. Two and Sofikul. And Abdul
No,
Haq is
during the search of the body of Abdul Haq,
yes.
8 numbers of so and so suspected heroin kept in. So from you, been recovered from his possession on being led by so and so, made shelter house so and so. So much again suspected. Some silver so and so.
They are selling these articles, Lordship, contraband.
If we send the CD, and when can we fix it?
The 68 day, Lordship.
Let's see what comes. Let the it appears that the mandatory period of 60 days is coming to an end on, is going to be expired on such and such date. It further appears that though the case diary is available in the court, is available with the with Mr. B. Sharma at APP for the state respondent. However, the FSL report is not available therein. That being so, let the case diary be returned to the jurisdictional police station for completing for updating the case records with and send back the same along with the FSL report. List on
2nd of May.
2nd of May.
60 days.
60 days is expiring when?
2nd of May.
So on a second you do it and list on second then?
Second.
Second or?
Second. The
Okay.
second will be Friday, Lordship, otherwise.
On such and such. Date. So you give a call also. এখানে কই বল না 52. What is this IA for? None appears for the appellant on call. List after 2 weeks on a date to be fixed by the registry. 722 days.
Please, Your Lordship. Lordship, unfortunately, I need to seek accommodation for the day because my senior had to rush to the hospital due to inflamed eye.
Due to?
Inflamed eye and reddish eye.
Yes.
Lordship, kindly fix a date in the coming.
Have you filed your objection?
Yes, Lordship.
All right. As prayed for by the learned parties, as jointly prayed?
No, Lordship, from there. Sir.
Okay, your name?
Hirai.
MSB, right? B for Bombay?
B for victory.
B. As prayed for by MSV, right, Learned Counsel for the petitioner on the ground that the leading counsel, Mr. S.P. Roy, had to, for medical reasons, had to leave the premises of the court, comma, list this matter when? After 2 weeks?
After 1 week, Lordship.
After a week on a date to be fixed by the registry.
Obliged.
Obliged.